Okay, so welcome to the last session of this afternoon, and it's a great pleasure. But first, let me thank the organisers and all those who inspired it, as well as all the hard work that went into it. It's been a really fascinating couple of days with some really interesting discussions that are both historic and contemporary, and I guess that's the function of this afternoon's session, is to connect the past with the present. So it's a great pleasure to introduce Bryan McMahon, who is formerly a judge of the High Court of Ireland. And Bryan is a leading figure in Ireland, both in the legal scene but also in theatre. So in a way, it's appropriate that the two were also brought together in this particular event. He's chairman of the Abbey Theatre in Ireland. He's also chair of the governing body of University College Cork. He had a long academic career at University College Cork as a professor in the faculty and head of the law department for 2 decades. And he was in private practice for some time after that, and also has written some of the leading texts in Ireland on mainly in the field of tort law, but also in European Union law, which is one of the subjects, or at least European law, which we'll talk briefly about in this session. He graduated from the same law school as Walter Walsh and I, that is University College Dublin, and he's had many other taken on many other public functions at the request of the government, including chairing the National Crime Forum, the National Archives Advisory Council, and referendums for the amendment of the Constitution. And I believe there are others not mentioned on his bio. So, Bryan, it's a great pleasure to introduce you, and let me hand over to you.
Thank you. Let me also start by thanking the organisers of this conference. It's been a splendid educational experience as far as I am concerned, and I am sure that the dynamic that we have heard this afternoon in the question and answer session will continue, hopefully, till the end of the session. I'm not going to explain this until the end. It's the confession box. It's headed for those of you in the back seat with a bad sight. I was heartened this morning by President Sexton's remarks in 2 respects. First of all, he said that being Irish, it allowed him to tell stories and to exercise some humour. And that I take as a green light for my presentation. And if I do fall into those traps, it's because of the president of this illustrious institution. Nearly every speaker has disclaimed at the outset, the historians disclaiming that they were not lawyers, and the lawyers disclaiming that they were not historians. I certainly am not a historian, and I probably am a lapsed lawyer now that I've retired from the bench. And I'm wondering, since those remarks struck me earlier on this afternoon, when does a lawyer cease to be a lawyer? When you stop thinking about law, or when you stop practicing it. Much of what I have heard today was very echoed very much with what I had prepared in the Irish context about what went on. And it's quite eerie that People versus Phillips was 130 years before the seminal case in Ireland, Cook and Carroll in 1945. And I know you've all been listening, so I'm not going to labour the point, but as I go through my presentation, bulbs should light echoing things that were said about the People versus Phillips, and they're totally 130 years apart. It's quite extraordinary. Having read the recommended materials and having listened attentively to the impressive speakers today, and I will confine myself to a few remarks relating to the evidentiary privilege, confessional and sacerdotal, as it evolved and as it survives in the Irish legal system today. The modern story does not begin until 1945, when the famous case of Cook versus Carroll was heard by Gavin Duffy in the High Court. And that case demands attention, not only because of its reasoning and the sources it relies on, and its importance as a precedent in Ireland, but also because it has subsequently been admired and cited on this side of the Atlantic in your federal courts in Mullen versus the United States in 1959. But first, allow me to make a few preliminary and general comments on the seminal case which is at present commanding our attention, the People versus Phillips, the bicentenary of which we are gathered here to celebrate this weekend. As chairman of the Abbey Theatre, the National Theatre of Ireland, I was very interested, needless to say, in the dramatic representation so beautifully and powerfully adapted and directed last night by Steve Diobaldo and Mr. Cedars, the director. Apart altogether from the substantive issue at stake, does not the courtroom present a wonderful setting for dramatic tension? The set, the costumes, the protocols and formalities, the cast and characters all contribute to the drama of the occasion. The parties take their places in trepidation, and the professional jousting between counsel during examination, cross-examination, and re-examination slowly and inevitably reveal, with each thrust and parry, a rising tension which leads to the final denouement, when the verdict is announced, which, needless to say, would have catastrophic consequences for one side at least. Inevitably, there is a lot at stake for the parties, for counsel, and frequently for the onlookers who might be immediately affected by the outcome or indirectly affected by the long shadow of the precedent established. It's not surprising, therefore, that the courtroom, and I'm conscious I'm speaking in the US, where courtroom drama in the television is almost every second, probably 2 out of every 3 programs are courtroom drama as far as I can see. And it's not hard to appreciate. But it's not surprising either that the classical dramatists should be attracted to the courtroom scenes. Consider Sophocles' Antigone, Brecht's Arthur Louis, The Crucible by Arthur Miller, Shakespeare Merchant of Venice, and Patrick Shanley's play The Doubt, where the audience is in fact the jury, and the final curtain comes down and you don't know whether the priest was guilty or innocent of the accusations made by the Reverend Mother against him. And you're supposed to carry on the debate and make your decision in the bar afterwards, and bar sales that put on that play show a great increase of income in that context. I was delighted, therefore, with the presentation last evening. Sometimes lawyers tend to overlook and forget how much we can learn from theatre and literature. We should never forget that both law and literature, to a large extent, deal daily with the same great problems of the human condition: birth, mating, and death. Apropos of a discussion that arose here just before the interval, I remember as a young student when we were asked to do an essay on capital punishment, the arguments for and the arguments against. And I spent 2 days in the law library going through the law books and making a big long list on the like an accountant, the entries and the outgoings. And after I had made my list, I looked at the 2 lists and I stood like a hungry donkey between 2 stacks of hay, not able to make up my mind. And I left it at that. But some years later, I read a book, a novel, called Cry the Beloved Country by Alan Paton. And I put down the book, and I was absolutely, totally convinced that no legal argument had ever convinced me that capital punishment was wrong. Now, I'm not saying in coming to that conclusion I came to the only conclusion available to people, but I was convinced by a fiction, a creative novel, of something that I couldn't be convinced by rational exposition. And that, I think, is important, because we as lawyers, in particular, need to have our experiences from other areas other than the law. We are first and foremost human beings. We are lawyers second. And on that issue, I think that it is worth contemplating for a time that whole issue that seems to me to be relevant. On reading The People and Phillips for the first time, and especially from acquainting myself with a comprehensive report of the proceedings prepared and published by William Sampson in 1813, some general observations are appropriate. First, from reading the report and the appendices in its entirety, one is immediately struck by the enormity of the task undertaken by Sampson on behalf of a small minority of immigrants, perhaps mostly, challenging the establishment on a serious matter of human rights. That the minority were Catholics is also significant, bearing in mind the religious persuasion of the majority of New Yorkers at the time. As one looks back now, it was a conflict that one categorizes, anachronistically perhaps, with subsequent equality assertions made on behalf of women, blacks, and the gay population more than a century and a half later. It heralded a political dynamic that was to be replayed many times over the following 2 centuries as emerging minorities asserted and demanded equality in new evolving contexts. Second, that the confrontation arose in a post-colonial context is hugely significant. It explicitly challenged the values of the prior regime in the rising wave of Republican rights articulated and derived from the French Revolution and adopted by a new emerging society in the Bill of Rights. That the challenge took place in a legal forum is also very relevant, since it is in the courts that the assertion of new rights has to confront all relevant principles and precedents if they are to prevail in a peaceful revolution. To succeed, however, in that context, one must engage successfully with all the technicalities of the law, including the primacy of the constitutional provisions, and in the absence of statutory rules, the establishment and interpretation of relevant precedents while considering, where relevant, foreign systems of law. In particular, in this instance, the canon law of the Roman Catholic Church may become relevant, for example. Moreover, once victory is secured in the courts, it means that the new rule is itself cloaked and blessed with legality that needs no more social validation. Third, that the challengers in Phillips were not only Catholic but Irish as well introduces an ethnic nationalist element into the mix, where the whiff of sulfur is patent. The prior historical abuse to which these new immigrants had been subjected to in their former homeland is strongly referenced in the court case and is paraded in an open and shameless manner to advance the argument. Fourth, the language employed by the amicus curiae in advancing his case from this remove is the robust language of the politician rather than the restrained language of rational legal debate and discourse. It is the language of the pamphleteer and appears to be more designed to quicken the crowds in the marketplace than to quietly persuade judicial uncertainty in the quiet, calm waters of the courtroom. Clearly, Sampson fought a legal battle that was intended to light political bonfires. And we've had from Professor Walsh this morning the beautiful insight into the history of the man that made him that political activist. Fifth, the subsequent publication and promulgation of the court's decision is hugely significant in my view when one recalls the absence of formal reporting and the limited methods of communication available at the time. Sampson, above all, was a publicist, and his political instinct appreciated that if Phillips was to have an enduring and abiding effect, it had to be broadcast widely and quickly in a permanent record. His experience in Ireland as a political campaigner and pamphleteer stood him in good stead as he exploited the legal victory to the full. One has to admire also his keen political perception that the legal victory was potentially of immense political and social significance and could have repercussions far beyond the narrow legal victory and the recognition in the courtroom of the confessional privilege implied. One must recall that Sampson was not a direct litigant in the affair, but someone who had insinuated himself as an amicus curiae in full recognition from the outset of the broader socio-political significance of the issue. Having identified the importance of the stakes involved and having invited himself to the party, he was not likely to be found wanting in broadcasting the ultimate victory. It's quite extraordinary to think that had he not taught himself a form of shorthand, we would never have benefited from all these wonderful records of that period. On such small things, history is turned.